Well, welcome to the U.S. Chamber of Commerce. My name is David Hirschman. I'm an EVP here at the Chamber and President and CEO of our Center for Capital Markets Competitiveness. It's my distinct privilege to welcome to the Chamber Securities and Exchange Commission Chair Gensler this morning. Chair Gensler has had a variety of really important high-profile government roles, private sector, academia. He, I think, is one of only two individuals who've chaired both the CFTC and the SEC, senior roles at the Treasury Department, was an advisor to Senator Sarbanes during Sarbanes-Oxley, and I had the privilege of visiting one of his classes up at the MIT Sloan School of Management, and I can attest he was also a very popular faculty member while he was teaching. Chair Gensler is always willing to engage with all stakeholders, including the Chamber, both when we agree and when we don't. And given the expansive agenda currently at the SEC, he certainly has proposed more than a few things where we do not agree. He rightfully chides me, however, about a Dodd-Frank report card we issued just over a decade ago where the CFTC got a C+. In my defense, most agencies got a lower grade, and they were just midterms. Still, I'm pretty sure Chair Gensler never got anything lower than an A at UPenn and at Wharton. Our gathering today is focused on climate disclosure. U.S. business is responding to the interests of investors by increasingly producing climate-related information in a variety of formats, including, when material, in SEC disclosures. Today, policymakers across the globe, from California and perhaps other states to Europe and Singapore, are moving to implement mandatory reporting requirements on climate-related information. There is a real risk of duplicative, differing, and even conflicting disclosure requirements. The Chamber supports climate policy that includes disclosure of material information for investors to use. And we all, I think, have an interest in avoiding policies that are distorted, duplicative, because of overlapping or conflicting approaches. This risk of fragmentation put the SEC's proposal on enhanced and standardization of climate disclosure in key relief at this moment. It makes even more important that the SEC's final rule meets the SEC's legal authorities and obligations. While the majority of our public company members already disclose climate-related information, there is room for improvement, especially in qualitative disclosures. And a final rule that is within the SEC's existing authority and based on materiality for a reasonable investor could benefit both issuers, investors, and the entire marketplace and help move this agenda forward. The Chamber appreciates the SEC's continued engagement with us on these and other topics. Chair Gensler, welcome to the Chamber, and thank you for this very timely opportunity to engage with you on these issues. And I'll turn it over to Tom Quaadman, Executive Vice President of our Center for Capital Markets, who will conduct a fireside chat with Chair Gensler. Please join me in welcoming SEC Chair Gary Gensler.
David, thank you very much, and Gary, welcome back to the Chamber. It's been a little while, but welcome back. Yeah, it's on. It's on.
It's good to be back, and you know, I'm trying to improve on that C+, but I understand that you might be grading the SEC a little lower these days. I do think, David, that when you gave out that report card, that some other agencies were also getting, maybe Ds.
Maybe.
Maybe.
Yeah.
But
I'll have to go back and check. But actually, David stole my thunder a little bit, but I did want to start with the fun question. You and Mary Shapiro are the only two to chair both the CFTC, SEC. Which agency have you had more fun in?
No, they're just both great agencies. It's a huge privilege, I'll just say this, to serve the American public in these types of roles. I'm a markets person. Some of you know I was at Goldman Sachs for 18 years. Neither of my parents went to college, and my grandparents, they didn't even make it into high schools in Eastern Europe. But, to be in a role like this is just remarkable. And at the core, what we're trying to do, as long as, God and the electorate give me in this role, and President Biden, and thank you, President, is really to make the capital markets work best for issuers and investors. They say we have a three-part mission: protecting investors, facilitating capital formation, in the middle, fair, orderly, and efficient markets. I just kind of think of it, the markets need to work for investors and issuers. It's not that issuers and investors work for the market intermediaries in the middle. Now, I get that some of the chamber's members are those market intermediaries in the middle, but I kind of, that's how I focus on the whole role. I know you want to talk about climate, but over to you, Tom.
Sure. Well, let me give a little bit of a frame because this is a very complicated topic and there's a lot for us to unpack in the time that we have, right? So 2010, the SEC releases guidance on climate reporting, right? And since then, we have majority of our public company members are doing reporting around climate risk. 2017, we issue a report on materiality. 2019, we issue principles on reporting. And we did that because we recognized, right, that the SEC at some point in time was going to do a rule around climate disclosures, and we felt those were the parameters that were going to be very important with that. But since then, we also have the European Corporate Sustainability Reporting Directive, CSRD. Everybody start getting used to acronyms here. SEC issued its climate proposal March of 2022. We have California just recently passing disclosure laws, which Governor Newsom signed into law just a few weeks ago. And we also even have the ISSB coming out with standards, right? And full disclosure, we had Emmanuel Faber here a few weeks ago discussing that. So let's unpack that a bit because there's a lot going on. And our members are really sort of looking around as to, okay, what's going on here, right? With all these, it's almost like a three-dimensional chess game at this point. But let's start in reverse. Let's start with California for a second. So full disclosure, right? If the SEC had come out with the California disclosure, I think it is reasonable to say our lawyers would be meeting in court, right? But there's going to be more to talk about with that later on. But the California laws are very sweeping. They encompass private companies, small businesses. Use one example, right? If I go into an In-N-Out burger in California and I have a burger, well, they're going to have to start to disclose whether or not, the cows had a low flatulence diet, right, to reduce methane. I mean, that's how far some of this goes. But California isn't alone, right, where you could have Texas now coming out with the law saying don't disclose. So we're looking at blue state, red state divide. But this is happening as you're in the middle of your rulemaking process. So how does it impact what you're doing?
Well, let me start. Our rulemaking and our remit is about investors making investment decisions. We're not a climate regulator. Can I repeat that again? We're not a climate regulator. We're sort of a disclosure-based regulator that issuers, 6,000, 7,000 public registrants. You usually focus on the top 1,000, but those 6,000 or 7,000 registrants make full, fair, and truthful disclosure, but it's about the investors. It's about materiality as well. What's a reasonable investor find significant in the total mix of information when they're making an investment decision? So that's what grounds us. And what we're looking at, and I will get to California, as you mentioned, but what we're looking at, and these are public figures, but in 2021, you could update these a year, and it's probably higher numbers, but in 2021, of the 1,000 companies listed in the Russell 1000, so roughly those top 1,000 companies, 81% already make some climate risk disclosures, and 57% do Scope 1 and Scope 2 disclosures. Probably grown in 2022. Far less on so-called Scope 3. Now, there's not consistency. There's not necessarily comparability. There's a role for the SEC to try to bring some consistency and comparability, and that drives efficiency in capital markets because then investors get something consistent. You asked about the law now that was passed in California. That may well change the number of companies, public companies, that are making disclosures. It's estimated, we at the SEC have not made this estimate, but in public reports, it's estimated somewhere around 1,400 or 1,500 public companies may indeed come under those, that law. The rules haven't been written. And apparently the law would come into being, 2026, 2027, it sort of rolls into place. So it can change the economic baseline, but still, we're a securities regulator. That's our authorities. And it's about investors making decisions and ensuring that the material information is not just accurate. President Roosevelt called the 33 Act the Truth in Securities Act, but it's also some consistency and comparability.
Let me drill down just a little bit further on that too, though. But so part of what California does do, it does impact securities disclosures, right? Because it references exchange rules, et cetera. But what if a Texas or a Florida was to do the exact opposite, right? So you get a red state set of policies, you get a blue state set of policies. If the SEC were to finalize a climate rule, would you consider doing a preemption statement on, obviously, which would only cover securities disclosures?
Again, you're talking in a hypothetical, so I don't know what those laws are. We deal with economic baselines as they present themselves. California's passed a law. Of course, you'll probably get to Europe. Europe has a law, and it applies to certain U.S. companies as well, maybe even thousands of U.S. companies as well. So it's investors and how they get comparable and consistent information. But you asked about preemption. Congress took that on in 1996 in a law called NISMIA, and that as a federal securities regulator, we have important responsibilities about the disclosure of the public companies, not private companies, not non-public companies, right, but just those 6,000 or 7,000 registrants.
So let's take a side trip to Europe for a second, right? So we've got the CSRD.
Have you been there recently?
May. I was
Good.
there last May, actually meeting with our EU friends in Brussels. So American public capital markets, right, are about 40 to 45% of the global public capital markets. Matter of fact, 4 times larger than Europe and twice the size of Europe and China combined. That's how big they are, right? And David referenced your work with Senator Sarbanes with SOX, and SOX sets the global standard, right? Gold standard for governance. So we've got the CSRD now out there, right, where I think the Europeans would like to see that be a global rule if possible. How does that factor into what the SEC is doing? And I do want to get to equivalence and recognition in a second.
A little background. I got in this job in 2021, but many companies were already making disclosures based upon a framework that was discussed and put together by a lot of private sector actors under, I think Michael Bloomberg might have led the charge, called TCFD, a Task Force on Climate Risk Disclosure, starting in 2017 or so. So hundreds and hundreds of US companies were following something around that framework. Not exactly the framework, but something around that. It is also the case that many European companies were doing that. So I just say that is a bit of background. But in terms of how does it influence us today at the SEC, again, what we do is under US law, and we're going to look to US law and how the US courts interpret our laws and our authorities. And it's about investors, investment decisions, and the information that's already being disclosed. So European law, I don't think it's all implemented yet, but as I understand it, has a certain reach to US companies having either listed in Europe or over a certain amount, a threshold of about 150 million euro of footings, and maybe it's 250 employees. And don't quiz me or test me on the numbers.
Don't worry.
But the point is, again, it will change some of the economics if potentially a couple thousand or more or 3,000 US companies are complying with that over there. But again, our approach is just trying to drive some greater consistency, efficiency in the public disclosures here. And by the way, we've gotten 16,000 comments into our comment file. And so, we're sorting through all that as well.
Yeah. So just, sticking with Europe for 1 second, Evan and I have met with, the various different officials over there multiple times. And one of the reasons why we're also talking with them about these issues is the equivalence issue, right? Because the materiality standards we have in the U.S. means that we're going to be in a different place than where they are, as well as with the litigation that we have here.
Wait, are you already suing us?
No, we're not suing you. No. I'm talking about companies being sued. Companies being sued. Let's be clear.
I'm
Who's
just
suing
checking.
who?
I mean, I just walked in.
Don't worry. We're not going to serve you with any papers today. Don't worry about that. But, when there have been other issues where there's a difference of regulation, right? There's a negotiation around equivalence and recognition. So as an example, right, the SEC has determined that foreign issuers in the United States don't have to file their financials in GAAP. They can do it through IFRS. But when we've met with the Europeans, they said, well, yes, conceptually that's true, but we're not going to recognize anything that doesn't have a double materiality standard, which you have even said we're not going to go there. So how do you see the recognition issues playing out?
Let me say a couple of things. In seriousness, we do what we do at the SEC based on U.S. law, based on how our courts interpret those laws, and we know from time to time you differ and you seek redress in the courts, and I respect that. That's part of our democracy. I might prefer that you not, but I respect that fully. Look, we have time-tested 90 years a disclosure regime at the SEC and in the courts, and it's about those investors and investment decisions. It's not about the climate. It's not about climate risk. It's about investors. And look, already, since that 2010, hundreds and hundreds of companies, 81% of the Russell 1000 are making climate risk disclosures. And investors are making decisions. That comment file I mentioned earlier, there's 16,000 comments. One of the commenters summarized other people's comments. So it was just kind of an interesting take on it. But when this group summarized, Series was the name, but summarized other commenters, it went through like $50 trillion of assets under management. Investors really do want some rule. Now, they differ with some of the details. I'm not saying they all agree on all the individual details. That's where we are. Europe, as you say, has a different remit. The European Parliament passed a law. It may well be with further reach than what Congress's authorities to us. But we're going to stick just to our authorities. One last point. I think for public companies, corporate America, a rule, if we're able to finalize it, it would be best if it's sustained in court. And maybe this is just my pitch to corporate America and the chamber, but no U.S. rule would mean that U.S. companies, and we're 40% of the world's capital markets, but it would mean U.S. companies, many of them would be looking to other jurisdictions and need to comply with those other jurisdictions. A rule sustained in court is then something that they can at least point to, and you can have those discussions. You can't prejudge them, but you could have discussions about whether it's called equivalence, because we won't be equivalent, but substituted compliance is usually a term that's used in these international discussions. Yep. Because they have a different law, and we are not solving for their law. We're solving for U.S. capital markets, U.S. disclosure regimes, and only the authorities that Congress has given us. Well, that's the goal.
So let's turn to the SEC proposal. You've referenced a couple times 16,000 comment letters. I'm amazed everyone in the SEC isn't walking around with Coke bottle glasses on from having to read all those letters. But what are some of the common themes that you've seen coming out of the comment letters?
How long do you have?
Well, we can make it as long as our comment letter.
No. legal brief. I'll split it in two categories, and in each of the categories have a few. The greenhouse gas area and the qualitative non-greenhouse gas. I'd say in the greenhouse gas, a lot of comments on scope 3, of course. The investor side, largely supportive of greenhouse gas disclosure, and again, with over half of the Russell 1000 already making that disclosure, you can see why investors are looking for that, but far less on scope 3. So it's more split there, but on the issuer side, a lot of questions and doubts and concerns. You can read the comment file. We recognize this in the proposal. We recognize, and we took a tiered approach. We did, the scope 3 wasn't as well developed yet. Also, we've got a lot of comments from the agricultural community, rural America, that said, look, we're a farmer, rancher, that we're not a public company. We shouldn't get caught up in this. And I agree with that. That's not, we only have remit over these 6,000 or 7,000 public companies. I'd say on scope 1 and 2, a lot of comments about timing. 3 months, putting it in the 10K and putting it in early. There are also comments, of course, well, could it still be filed, or furnished, not filed, things like that. I'd say in the non-greenhouse, I'm sure there's other points. attestation, points, meaning outside assurance. In the non-greenhouse gas side, I'll just mention a lot of comments around the footnote disclosure. There was the current financials, particularly around transition risk, comments about the sensitivity, maybe proprietary information around the scenario plans, that one competitor wouldn't want to disclose to their competitor, things like that. I'm sure I've left out, I know that you all, your comment letter, had a lot about liability and materiality, and the board seat was another thing.
Yeah. So let me.
How'd I do?
Did okay. No, you did okay, but you've
That
read
doesn't
through.
mean we're going to, listen, we've done this. We've now finalized, while I've been here for 2.5 years in this job, 27 final rules in various different areas. Some related to China issuers in the U.S., some related to private funds, some related to, cyber risk disclosure that we chatted a lot with the chamber about. In nearly every one of them, we make adjustments based on that comment file, because we make adjustments based on the economics, the cost-benefit analyses. We make adjustments based upon the legal analysis. But ultimately, the commission staff does a really great work, serves it up, and then 5 commissioners, come together and see how we, find a consensus.
Yep. So I want to get into 4 areas of concern that we have raised consistently. And let's start off with scope 3, because who can have a discussion around climate without scope 3? But let me give an example, right? And let me stick with the cow example for a second. So
I'm sorry, cows.
Cows.
Okay.
Yeah. So my wife tells me to go out and get a, carton of milk, right? So I jump in my car. The auto manufacturer who made my car has to, disclose the emission. There are 30,000 working parts in my car. That there are public companies involved in that has to be disclosed. The insurance company that insures my car has to disclose those emissions. The REIT that owns the shopping center where the supermarket's located, where I park my car, has to disclose those emissions. The supermarket has to disclose it. The dairy manufacturer has to disclose it. The carton maker has to disclose it, right? So 7 different forms that I am missing, right? You can multiply it out, right? Out of all those they're all counting the same emission, right? How is that relevant to the marketplace? How is that material to the marketplace?
Again, we're not a climate agency, but what investors have told us in the comments that they've sent us is that understanding the emissions of a company's supply chain, and this is from investors, but understanding the emissions of the supply chain helps understand what's called transition risk. You know, what might be the future for that business, and it might be transition risk because customers may buy different products because of the emissions of a supply chain, or regulations may change, or even employees may want to work for one firm versus another. But it's really the only remit we have at the SEC is through that. Is it material? And we're not changing any materiality standards. It's just the Supreme Court classic one about substantial likelihood that substantial likelihood that a reasonable investor would find it significant to the total mix of information in making an investment decision, buy, sell, or a proxy vote. That's just the, straight from the law of the land, the Supreme Court. But that's what investors have said. We recognize that it's not as well developed in our proposal. And we said, well, this isn't like the greenhouse gas of the company itself. But there's still, as I said earlier, a lot of commenters on the issuer side and then the private sector that said we shouldn't get caught up. Last thing on Scope 3 is what we proposed. We got a lot of comments on this, is that the public registrants, all they needed to do is if it was material to them, so they'd make a determination if it's material. If it's material, or if they made a public commitment to managing Scope 3, so that's their choice. It's kind of an if-then, if they make a commitment, then they would disclose it, but they can use estimates. But we did get a lot of feedback that those estimates might then lead to, the companies asking the supply chain for forms and numbers and everything like that. And so that's why staff's looking through as to how we can ensure that we don't indirectly sort of do what we can't do directly. We don't regulate non-public companies.
No, and we've been very clear on that. No, appreciate that.
There may be differences between the chamber and this chair at the SEC, but our remit is just what Congress gave us. It's about these public registrants.
Reg SX, right? There's the individual line item analysis. And there I would argue that even investors have said that's not necessarily material, and that there's a real issue in terms of the cost and burden to go through that, that you don't really get the benefit out of that. Is that something that the SEC is looking at? And
so just as a little background to those listening and in the room, in our proposal, we said that on your current financials, to have a new, I think we said footnote, but a new disclosure in your financials about your current year effects of the climate risk. If you had a severe weather event or the funds that you're spending on managing these transition risks. A lot of feedback. Like we know, the comment file is full of feedback on this point, particularly the second aspect. The severe weather events, there was comments, but on the second, like how does a company actually manage and add up and tag and track what they're spending? If you build a factory, you could build a factory for 10 different reasons, and it might be partially for transition and so forth. So we're kind of looking through that. And then also, there were a lot of comments because it was, I think, line by line as contrasted to the entire balance sheet or the entire income statement.
So just to go back a little bit, though, that from our analysis, investors aren't looking for this information either. Is this something that you would say if you determine it's not material, it wouldn't be in a final rule?
Again, I don't want to prejudge a final rule. I sort of give you a sense of what we're hearing in the comment file, but these are the current financials. This is not projecting forward. It's the current financials. And for instance, if you had a severe weather event at some level, and we could debate thresholds, at some level, like that's important to put in a footnote.
Yep. So implementation periods, right? And let me just set it up a little bit too, where your EU CSRD, I think, has delayed some of its implementation. Governor
Let
Newsom,
me say, honestly, you're probably closer to what they're doing in Europe than I am.
yeah,
Because again, we're focused just on this here, but. all right.
understood. But they've decided they're going to delay some of their implementation. Governor Newsom, in signing the California legislation earlier this month, said, well, even though we have a 2026 deadline there for disclosure, we don't think that's a feasible target. The SEC proposal has a very aggressive implementation period. How are you looking at addressing that? Because we have heard from many companies a concern about the aggressiveness on that, because it's going to take some time to get systems up and running, with however the final rule ends up.
Look, again, we get comments on implementation period, but if I recall, I thought that much of what we did was the non-greenhouse gas side, I'll call it the qualitative side, and the footnote side, possibly along with Scope 1 and Scope 2, was for the first full fiscal year that's after it's in the Federal Register. So, you can, I don't know when it will be in the Federal Register. I mean, it's still more, and I'm not announcing that here. And then it sort of, that was for the large accelerated filers, and maybe it was like a, phased. Scope 3 was later. Of course, we've heard a lot of feedback on Scope 3, and then I think the smaller filers were later as well. But I would note right now, you asked about these others. I think California is, things could change, but I think it's 2026 for full year fiscal 25.
Correct. Yeah. Well, and as I said, that's something that we've heard a lot from companies on. I just want to go back to materiality for 1 second. You even had referenced that 81% of public companies are already doing climate.
This is of the Russell 1000.
Correct. Are doing a form of climate disclosure, and they've worked that out in terms of their relationship with their investor base to create that. So to some degree, we're really just looking at making some qualitative improvements or some quantitative improvements. So is there a way to have a more narrow approach that allows for the disclosure, that we avoid the increase in costs, right? Because if you take a look at the cost that the SEC has estimated, right, this dwarfs SOX 404B. And if you take a look at our Overdahl report that we included with our comment letter, we think it's much more than that. So it's a way of saying, can we get to material disclosures without the costs that I think are associated with the proposal?
Well, look, again, that's what we do. That's what the staff has been doing. Look, the economists, also our Office of Chief Accountant, our Division of Corporation Finance, looking at those costs and benefits. A lot of the comments are around that footnote disclosure. That was part of the piece of the cost factors. But that's something that we're looking at. But if you've got over half, and this is in 2021, over half of the Russell 1000 disclosing Scope 1 and Scope 2, far less on Scope 3, I understand. But that sort of affects some of those costs and economics as well, that they're already. Now, bringing consistency actually benefits capital formation. Now, you might have a different view, I don't know, but I think it benefits capital formation. And if somebody wants to go long or short what they read, that's up to the markets.
So last question. Let's just take a look at competition and capital formation for 1 second, right? So we've talked for years about the decline of public companies and all that. However, about a month ago, David and I also run 2 other teams at the Chamber. We also run our tech team as well as our intellectual property team. And our CEO, Suzanne Clark, had asked David and myself and some other members of the senior leadership team to do a series of meetings in Silicon Valley, which we did. And then I was back out there in Silicon Valley about 10 days ago. And the meetings were about AI, quantum computing, metaverse, right? So not financial services at all or corporate governance at all. Every meeting we had, there was a discussion that the companies raised about the changing financial environment, right? Which you would expect with the rise of interest rates, some receding of VC funding. And the point that they were making was, well, the next way that we can actually raise the capital we need is to do an IPO, to go into the public markets. But then it was quickly followed with, we think there are a number of different regulatory impediments, which does not make that attractive for us. So I raised that, and we can have a further discussion on it, and I know there's going to be a congressional hearing on it next week. But are you also looking at the climate proposal as to what the effect is in terms of companies going public, companies remaining public, and then what does that mean to the overall markets that you regulate?
We do a robust economic analysis, and it's about, in this case, it's about those public companies. And so I think we have a robust public market, we have a robust private market. And I think the U.S. benefits that we have both. And look, Congress weighed into this multiple times, all the way from the 1930s, but most recently in a big way on the Jobs Act. And again, we do things within the authorities Congress lays out. And this rule is about trying to bring consistency around those public companies. But if somebody does access the public markets, and if particularly if they're a large accelerated filer, which is about 1,100 companies, just to scale that, depending upon any day's market values, because it depends on market cap. A majority of those are already making some of these disclosures, and it's because investors are asking for these disclosures. Investors are making investment decisions based on these disclosures. So I don't know, I think that's a net plus. I also think, again, I'm saying this, I think that your corporate members, those in the room and those listening, you may not have written this in your letters, but I think you want us to be successful. I think that it will benefit the capital markets, that the U.S. Disclosure regulator, the SEC, the securities regulator, has something more than our 2010 guidance on this. And I know there's a lot of thoughtful comments on the issuer side that wants us to do moderation and change this, change that. But I'll tell you, the investor side almost uniformly really wants some consistency around this disclosure. So that's what we're trying to do.
So Gary, I want to thank you for coming today. I think Politico had said, or somebody this morning said, oh, Gary Gensler's coming to the Lion's Den. So I hope it wasn't that bad.
Okay, let me say this. I don't know. I mean, this is, I'm really remarkable that I'm serving my third president and I'm doing this. It's just a remarkable thing. I believe in this democracy. I believe deeply in it. And this is part of it. It's having this exchange. I remember in the Obama administration, I called David up at one point in time and I said, I have a proposal for you. He said, what's that? I said, can I meet with a bunch of your CFOs? He said, on what? And it was on this derivatives work that we were doing. And David said, all right. And we had these meetings. We just had these meetings. And he called me up a few months later and he said, you did something unusual. You split our membership. I said, I'll take that any day. That's probably what I got a C+. I would say this about the company letters, the issuer letters on this topic. It's not uniform. There are issuers that really are supportive of what we put out. The footnote disclosure maybe aside, but and then there's some that are fully, in opposition. I mean, it ranges. I get that. We're trying to do something to help bring that consistency within our authorities. And we benefit. We truly benefit every day from hearing from issuers, hearing from the Chamber's members. We don't always agree. I'm going to close on it. My mom's brother used to always say, you do this at weddings, but Uncle Norman would always say, though you may not always agree, may you disagree agreeably. So that's all. That's like, we have a different client base. Our client base is the American public, the issuers and investors, where the investor advocate is, as William O. Douglas said, in '96, Congress put into the laws that we facilitate capital formation. Those are our clients. You have your membership as your clients, so it's a little different. And so we're not going to always agree, but maybe at least disagree agreeably.
Well, we will, I know, David, Evan, and myself would be more than happy to tell Uncle Norman that you and your staff have had an open door policy, which we appreciate, and I think we've had very good discussions, and we're going to wait to see where you end up. So thank you.
Thank you.
Evan, turn the floor over to you.